So much has changed in the landscape of South African healthcare over the last while. We've had the introduction of POPI. We've had the introduction of, or rather the tabling of NHI. And these are all themes and things I want to discuss with you as we go along. But I think maybe where we can start is you've had the ability to take a snapshot of healthcare over the last 5 to 10 years. How has the landscape really changed? And how has the behavior between patient and practitioner and even payer changed during that time? If you can just tell us about the South African landscape and what observations you've seen over the last while.
Thank you, Basil. So what we do find is the number of malpractice claims has increased exponentially over the past few years, and not only the claims, but also the quantum, the number of claims, but also the quantum of claims. And there's no single factor attributing to this increased claims. There's numerous factors. For example, could be lack of proper informed consent, poor communication, poor record keeping, and also now more than ever, patients are more aware of their rights in terms of Consumer Protection Act. Patients now are expecting a better outcome, a better health outcome than previously because of the information available to them. What we do also find that often patients would because the HPCSA is kind of freely accessible to them to lodge a complaint, sometimes patients would use the HPCSA as a platform in order to avoid paying a medical bill. And the doctors or practitioners, unfortunately, they face the brunt.
Wow. I don't think that really makes for a very healthy healthcare system, but unfortunately is the state of play that we find ourselves in. So the service that Medrisk offers and what you guys do, I think is just even in educating practitioners is probably something that we find increasingly more necessary these days. And I mean, it's actually quite shocking how little education we get on this when we're actually studying at university level. We don't really get much education on this kind of thing. And we go into it because we want to help patients. Most medical practitioners don't get into it because they want to buy a Bentley or have a house in the hills of the city or whatever. They go into it because they want to help patients. And so it's disheartening when we have to think about this element and the fact that we have to protect ourselves against this kind of thing. But I think maybe to start off with, can you maybe just highlight what are some of the areas that you find many medical practitioners just don't have cover in or don't really think about when it comes to administrating their healthcare, so to speak?
What we do find, so maybe we'll first look at allied healthcare practitioners and GPs, and then we'll go to the specialists and institutions. So with allied healthcare and GPs, if they're opening up their own private practice, there's no formal need for them to have malpractice insurance, and they can decide whether they want malpractice insurance or not. Often we find that sometimes the doctors would only take out cover once a year of a colleague that, had a claim or a lawsuit against them. When it comes to specialists in private practice, usually before obtaining admission rights, the hospitals require malpractice insurance. So they need to provide them with proof of insurance before they can enter private practice.
I think just picking up on that, I mean, you mentioned those are primarily outpatient, primary healthcare type of practitioners. You also mentioned that there's definitely different levels of it when it comes to specialists and when it comes to hospitals or facilities, so to speak. What are some of the requirements that they might have to have in place?
So specialists generally need malpractice insurance before they can enter private practice. So before they even get admission rights. Specialists are not employed by the private hospitals. They generally are just subcontracted, but in order to perform any procedure, they need the insurance in place. Often when there is a lawsuit, the lawsuit would be against the hospital and the specialists or all doctors involved.
I think I want to take this conversation in the direction of just talking through how the practitioner absorbs hearing the news that they're potentially going to have a lawsuit against them. In your experience and when this kind of thing happens, typically speaking, what are the series of events that happen from the moment that they are informed about it to the moment they contact someone like you, and then all the way through to maybe, if it ends up in front of the HPCSA or hopefully not even in court.
Say a practitioner starts off in private practice. As soon as so like you mentioned earlier, these practitioners enter private practice in order to assist and to help patients in achieving a better health outcome. Some patients, however, aren't very transparent with doctors, so they will go through and maybe there's a minor complication. Doctor helps patients, sometimes even giving treatment for free. I had a case recently where a doctor, she was 2 years in private practice, or obstetrician, suddenly got a letter of demand from an attorney. And she was quite shocked because she done all her best to help this patient. And you mentioned about the time period. So usually when a patient receives their first complaint, me or one of my colleagues will be the first people that they contact, share their agony, and we do give some type of counseling because unfortunately the reality is that most specialists entering private practice, unlike in the past, would go through some type of complaint even if they're doing their best as a healthcare practitioner. So the reality is malpractice claims are increasing annually or exponentially, and patients or doctors should be prepared for it, but they're unfortunately not.
It's very, like you mentioned, it's very disheartening. Not a really nice topic to speak about, but we have to talk about these things. And I think if you're a medical practitioner and you don't have this information in place and this kind of cover and this kind of assurances in place, it kind of detracts a little bit from your ability to be able to perform your best work. Because now if you're concerned about all these different elements, you're not able to concentrate on the clinical care that you have to render to this patient. It takes away a little bit in terms of the real attention you have to give toward doing your best work. Now, obviously, medical practices are multifaceted organizations. You've got front desk people, you've got, in some cases, billing managers within these practices, and then other referral practitioners that you're working alongside. And that information has to be shared. If you can maybe just touch on how that information is shared in most medical practices, and if you don't have the proper documentation and processes in place, what are some of the implications and some of the legal parameters that you might be infringing upon by not having those things in place?
So what we do find that most of your larger institutions, your hospitals, they do have formal POPIA compliance processes, and they are POPIA compliant. They have maybe attorneys assisting them with it. Where we find there's a big problem is amongst the smaller practices where, say, doctor that's a neurosurgeon, newly qualified, enters private practice, has got no formal administration or business skills, hasn't acquired any of that at university, and now suddenly is required to run a business. Besides treating patients, he needs to be responsible for patient information. And what we do find that since July 2021, so this is a statistic based on practitioners we speak to, and we speak to doctors all the time, I would comfortably say about maybe 70% of all practitioners are not POPIA compliant.
That's incredible.
That many are not POPIA compliant.
Not POPIA compliant.
Not POPIA compliant. They're not even registered as information officers.
Okay, so let's just break this down a little bit. So this is, and I want to stop you because this is critical what you're telling me right now. As a medical practitioner, when I was practicing, I had to share information with other practices about the clinical care I was rendering. If I was referred a patient by another colleague, I would have to give feedback to that one. If I was referring them on to another colleague, I would have to give feedback to them, and I would have to maybe give feedback to a family member of the patient, for example. And if I didn't have those things in place, I'm technically liable, even though I'm acting in the best interest of the patient, I'm technically liable of I'm breaking that POPIA Act. I'm sharing information without their consent. And you're telling me that 70% of practices probably don't have this in place, close to, from what you've seen, at least the data that you've been able to retrieve.
Yes, so I would say 70% of new practices, yes, you are correct, Basil. And it's the solution is quite simple. There's a simple form doctors make patients sign, and we recommend usually in the onboarding process where patients basically let them know ahead of time which family members they can share information with, and also patients allow them to share information with other healthcare practitioners as long as it is in the spirit of treating that particular patient.
Okay. All right. So yeah, I think if practices don't have that element in place, they should definitely, with a lot of haste, get to the point where they get those things in place for sure. I want to pivot a little bit and talk a little bit about the technological side of malpractice and also cybersecurity and cyber insurance as well. Practices are increasingly utilizing more online tools, online note taking. In the case of patient awareness, they're making use of social media. Some of them might even be running campaigns on things like Google. They're getting information in from their electronic health record systems. So information is floating all over the place online and within a computer database. And so that has changed a lot because I think even just with electronic health note taking or electronic health records, the adoption has been crazy over the last while. Most practices are now utilizing the computer. They're not doing handwritten notes any longer. But they're not really thinking about the implications of that and the potential for hacks and the potential for the information being leaked. I'd like you just to dive a little bit into it. I know there's a fairly new sector, even for you at Medrisk, to get into, but maybe just give us a little bit of insight into some of the areas that medical practices are not thinking about, or medical practitioners are not thinking about in the case of cyber insurance and in the case of data that is online.
So maybe, Basil, if I can share a story with you, not necessarily a story, but recently there was a case of NHLS, National Health Laboratory Services. Their systems were breached. All patient information was compromised and not usable. Doctors were forced to treat patients with no patient information available. And in certain instances, surgeons had to perform emergency surgeries without blood tests, or they had to wait too long for blood tests. And naturally speaking, this would increase not only your cyber risk, but also your exposure to malpractice lawsuits. So the 2 years, even though they run parallel, they do intersect at times, and both are important. Why we find a lot of professionals don't have cyber insurance? Because number one, they think, no, it's not going to happen to me, especially the smaller practices. And then number two, it's not compulsory for them to have it. Like with malpractice insurance, hospitals are actually telling them in order to practice, you need malpractice insurance. With cyber insurance, there is no such requirement. And yes, but I do anticipate, and we do see the uptake of cyber insurance in the healthcare industry is increasing. Slowly, but people are becoming aware of it.
If you have a telehealth service in your practice, do you think that you probably should have cyber insurance, a cyber insurance product attached to your practice as well?
So definitely yes. And while you mentioned telehealth, also going back to malpractice insurance, telehealth or telemedicine is not seen as desirable risk to most insurers. And that's because of the inherent risk of misdiagnosis or delayed diagnosis. My advice to doctors that do treat patients via this platform is to make sure you let patients know of the limitations of a telehealth consultation. If there's any major complications, or maybe there's some type of illness where you're not remotely sure of, either arrange for an in-person consult with that particular patient or refer them to one of your colleagues.
So having some kind of framework or strict parameter around, or triage system around what patients are able to be treated via telehealth versus what are not, and having that directive put into your practice as an actual procedure, standard operating procedure, you reckon is imperative to making sure that you limit your risk on that platform.
You spot on, but what I would also recommend is for those that are doing quite a bit of telehealth or even doing any telehealth, like I mentioned earlier, a lot of insurance don't see it as desirable risk. So please let your insurer know that you are doing telehealth. So I recently came across somebody that, not my client yet, doing 100% telehealth, but they are insured with a provider that would not cover them for 100% telehealth. I did let the doctor know, and they are going to make the necessary change.
Yeah, yeah. Now, these are critical insights, and I think yes, we want to adopt new technologies. We want to make healthcare more accessible, and these technologies allow for us to do that. But we also want to make sure that while adopting them, that we have the necessary things in place to be able to ensure that we can continue to practice with ease. Because at the end of the day, if a lawsuit comes your way, you can't help any more patients. It's game over. I mean, you worst comes to worst, you get to a point where you have a critical lawsuit where your license gets suspended, for example. The amount of patients you can now help is zero because you're not able to treat. And so getting these things in place and making sure that you are protected is critical to making sure you reach your own goals, which is to help patients. So I want to talk a little bit about as we see healthcare changing in South Africa, and with the technology adoption that we're seeing, there's definitely an emphasis on value-based healthcare and making sure that all parties, payer, providers, and the patient are informed in the decision and that everyone has equal value or as much value as is possible in that particular scenario. And a big part of that conversation right now is NHI. I would be remiss if I didn't ask. I want to also talk to our public servants as well, those working in the state service. And before we get to the NHI conversation, I want to find out from you. We focused a lot now on the private practitioner. Let's talk a little bit about the public servant and the public practitioners, those working in state, and what insurance products they might have to think about in order to protect them and their careers going forward.
So, with regarding firstly, the state hospital. So they're not seen as desirable risk for any insurer. So the Department of Health, unfortunately, would be responsible for any medical legal claims. But the practitioner working for the state hospital, many of them believe I can't be held liable, so I don't need cover, which is actually incorrect. So there are quite a few insurance providers that provide support cover for doctors or any practitioner working in the state, where it will cover for things like defamation or HPCSA matters. So I've seen recently, I'm interacting with a doctor, uninsured doctor, dealing with a HPCSA matter, and it can be very lonely and an expensive process, especially if you're dealing with it alone. So yes, definitely, I would recommend that state doctors would at least consider some type of a support cover. And what we also found in this particular matter, that the hospital said, no, you're on your own.
Okay, so earlier I mentioned NHI, and this is a topic that in the world of insurance hasn't really been discussed much. Because if we think about the possible permutations that could come as a result of NHI, it follows to say that the malpractice insurance space and cybersecurity insurance space is going to be something that is going to be a bit of a hotbed, if I think about it. Because if every medical practice in the country is going to be able to service every single patient in South Africa, the amount of patients that those practices are going to see is going to explode. Now, at the moment, you're saying, if I'm seeing a state patient, the state will cover any malpractice that comes my way. But if I'm now a private practice, seeing patients through the NHI fund, is the state going to cover that, or am I going to have to cover that? And maybe just your thoughts that I know you couldn't possibly give any real in-depth insights, but just from what you're seeing as an expert in this industry, what do you think most practitioners have to start thinking about when it comes to NHI?
So recently, in fact, last week at the airport, I met somebody that's consulting for the NHI, and I actually posed that question to him regarding the malpractice insurance. And he told me the same thing you just said, I don't know. And that's probably my answer. But that being said, we can make certain deductions.
Yes.
That I'm assuming that doctors will probably still need to have their own malpractice insurance. But certain regulations will have to change, but that will probably happen in the next few years, and I'm sure maybe 5 years later we'll have a better idea. But I do believe that doctors will still need their own cover in place. So it's not going anywhere, because as it is at the moment, the state already can't afford the claims coming
I've
their
heard
way.
about the backlogs, yeah, and they are immense, and just the size of these claims as well, as you mentioned earlier in our conversation, is also increasing and skyrocketing. So, I'll be waiting with bated breath to see what the implications are going to be going forward in this particular with this particular bill that's going to come into fruition now. With that being said, though, I want to bring the conversation back to the single practitioner. What are some of the steps that you would advise a practitioner to take immediately now with regards to making sure that their practice is set up and best protected for a malpractice lawsuit?
So, number one, what I always recommend to my doctors, don't take on more work than you can. You've only got so much time in the day. I would like to highlight two particular guidelines published by the HPCSA. That's booklet number 9 on patient record keeping, and booklet number 5 on informed consent. Freely available, and there's also numerous articles, YouTube videos where you can upskill yourself. With regarding record keeping, you can never have too little records. Informed consent, and informed consent will always protect you if it's done properly. I mean, I've come across a case, wasn't one of my doctors, luckily not, but I heard of a case where a doctor, orthopedic surgeon, I think, basically had the patient signing the consent form and gave the patient the only copy of the consent form. But it's simple. It's just upskilling as regular, continuous professional development, making sure you understand and you are better prepared. And yeah, that will, your informed consent, your record keeping and communication, importantly, will protect you in a court of law.
Yeah. I want to just also just highlight there are certain pieces of national legislation that come into play, like we mentioned, POPI, Public Access to Information Act as well, and having those facilities available. We spoke a little bit earlier about the appointment of an information officer, and I think when I did my practices POPI regulations and compliance, when on the appointment of the information officer, it said that the information officer is liable for up to 10 years in jail and R1 million fine or something like that. I could be wrong where that is concerned, but like that position then is quite serious. That you have to appoint that person with a lot of trepidation. You can't just be appointing anybody as an information officer. I mean, those kind of documentations and processes in place. If you can maybe just speak to those things that every practice should have.
Yeah. So. Basil, thanks. So regarding the numbers, it sounds right. I could be wrong.
Could be wrong, yeah.
But,
don't quote me on that.
But that being said, and I always tell my doctors this, if I was the information officer and I'm looking to make easy money, I'll go after doctors because they're not compliant. Yeah. And it's not difficult to register as an information officer will take you 5 minutes only.
And that's tough to hear. Hey? I mean, if you think about the fact that medical practitioners by and large are here to help people. They're by and large here to assist patients to get better. They got into this profession because they want to help people. And now to hear from you that they're becoming easy targets in this space it's disheartening to hear that this is the reality that we live in. And it's, as you've mentioned before, it's not all patients, but most patients are looking there to get better. But patients are more empowered and more informed than they've ever been, and they are looking for an outcome, perhaps an outcome that is not attainable by any medical practitioner, but you happen to be the one in front of them and they didn't get the outcome that they were looking for, and now they blame you and they're going to make you pay as a result. They're going to cause you anguish, they're going to cause you angst, they're going to cause you financial loss, professional loss, professional image loss, and potentially take your ability to even earn for your family away. And that to me is something exceptionally scary. And I think just to maybe land this conversation nicely, I mean, if I think about what a practitioner is going to go through when hearing about this, when they hear about a malpractice lawsuit, or they've received a letter of demand or some kind of legal communication from a patient, what are the first things they should do? And maybe it's just some advice as to how they should process it internally. I know you're not a psychologist, but you deal with this a lot of the time, and you've seen the faces of people when they go through this. So
Yeah, so maybe my recommendation is take a step back. Right? Take a step back, read the communication. Don't panic. Remember, it probably won't be the last time you receive such type of communication. And then the next thing is contact either your financial advisor or your insurer's claims team and ask them for assistance. But very, very importantly, do not respond to and surprisingly, I see you nodding, Basil.
yes.
I've had numerous cases where a doctor gets maybe a HPCSA complaint and say, this is frivolous. It's stupid. I'm just going to respond directly. I don't need my insurer. And they actually compromise their position. And there was even one case where the insurer said, you know what, we can't assist you further because you put yourself in a worse position.
Oh, goodness. And that's really tragic when you've taken all the steps, you have the cover in place, and you don't utilize it in the way that you ought to. So with that being said, Jamal, let's talk a little bit about Medrisk. How does Medrisk assist medical practitioners and medical facilities to become compliant in these matters and to navigate these waters in a way that is a little bit more sane and gives them a little bit more comfort?
So thank you, Basil. So just maybe a little bit more about Medrisk. We actually one of the largest independent brokerages in the country. And we're dealing with numerous, mainly on the specialist side, but GPs, physiotherapists, speech therapists, as well as institutions. And there's a lot of people out there that can provide doctors or institutions with insurance cover. But what we do, we try to go a step further. Our focus not only on the insurance aspect, but try to see which gaps the doctor has in terms of medical legal risk, which gaps they have in their practice, and how we can actually close those gaps. So maybe just a good example was actually something that made me feel very nice. In fact, this morning, I went to Cape Town Mediclinic. I went to go see a surgeon. It's a new potential client. And I met her a few weeks ago at a conference, and she mentioned to me, Jamal, thanks a lot for your informed consent template. I've looked at it and I've changed all my documents in order to comply. So this particular template that we've done was in conjunction with a top medical legal attorney, in South Africa. And so we try to do this little bit extra. We've even done a booklet where we summarize the HPCSA guidelines on informed consent, patient records, even reporting obligations to your insurer. A lot of doctors aren't even sure, depending on the type of insurance they have, when are you obligated to report a matter to your insurer. And so we try to make it a bit easier because we understand healthcare professionals on the whole don't like reading.
No.
Not all of them.
There's a lot to read.
Yeah.
And so, when it comes to these kind of things, they generally just want to get back to the clinical notes. Yeah.
So we try to summarize. And what I always tell my clients is you can read this booklet on a plane.
Yes.
And I can actually have that booklet freely available. If anybody reach out to me on LinkedIn, just put the survival guide and I'll send you the booklet free.
Fantastic. I think that's a great value add for our listeners and for our viewers that are taking the time to sit down with us today to really get through the quagmire and the potholes and the myriad of things that could go wrong when it comes to these type of matters. And so, Jamal, I just want to say, is there anything that I haven't asked you that I think I should have asked, that you think I should have asked you, or that you would like to say just before we close the chapter on this one?
So Basil, maybe just one or two things I'd like to add. Also on the last point about Medrisk. So we have presence countrywide. So whether doctor wants to see us in person or online meeting, we are available.
Fantastic.
And maybe touching more a little bit on the cyber insurance aspect. I think we just in terms of what practitioners or providers can do. So number one, what we find is a lot of the smaller providers haven't put enough emphasis on cybersecurity. I mentioned that earlier, but maybe what they should be doing is, number one, try to understand the risks associated with their practice. and then increasing the cybersecurity. Put some budget into it, because that will prevent future losses and inconvenience. And then number 3, give staff training. I mean, let staff must know what the phishing email looks like. And then lastly, add cyber insurance as an extra layer of protection. No system is infallible, and cyber insurance will just help you when everything else fails.
And that's also, again, what's encouraging to have, why it's encouraging to have these products available, because you could have all of the informed consent documentation, all the POPI documentation, all the processes in place. You've done the training. Your website is set up in a way that it negates any of those attacks. You do everything right every single day. There's just that one day where a process maybe didn't go according to plan. And that's the day that this thing happens. And so to have that layer of security in place, I think just makes you be able to focus on the main thing and keep the main thing, patient care, and be able to let the other things rest with other people. But yeah, thank you so much, Jamal. Very insightful conversation. I really appreciate your time. And it's something I think needs to be spoken about a bit more in the South African healthcare landscape. I think we've touched on a number of topics, both from the private sector to the public sector, the advent of cyber insurance, the advent of the need for cyber insurance, and the various things that come about as a result of the internet and the ever-increasing way we're living and treating online as well. And then finally just landing on what you guys do as Medrisk and how you can help and assist people and the work you guys already are doing to help practitioners all across the country. So thank you very much for your time. I really do appreciate it. And yeah, I look forward to sitting down with you again. I believe you got some new products rolling out and I'm very excited about it. So we'll definitely chat about that and how you are further helping medical practices thrive and grow in this ever-evolving and ever-changing world in South African healthcare. So thank you again for your time. I really do appreciate it. So once again, thank you so much for joining us for this episode of Vital Insight. I thank you so much for your time, and I hope you learned something today. I hope you're going to take the steps that Mr. Ismail has spoken about and really think about the ways that you can improve the way you practice, whether you be in the state or whether you be a private practitioner, so you can go on treating patients and doing your best work without the worry of these kind of elements affecting it. So thank you again so much, and until next time, see you later.